Hello, everyone. Thank you so much for joining us for today's free webinar, Startup Killers and Killer Startups, with Kevin Smith from SEEDCHANGE and Glenn McCrae from Early Growth Financial Services. I'm Erica Malsberg, and I'm the Chief Marketing Officer for Early Growth Financial Services, and I will be your moderator for today's presentation. It's going to run about 40 minutes or so. If you have questions as we go along, please feel free to enter them right into the question field, or you can also tweet them to us at Early Growth FS with the hashtag Startup Killers. Don't just raise your hands, just feel free to jump right in with those questions. This is really meaty content, so I'm sure you're going to have some questions, and we'd love to help you out. If we run out of time and don't get a chance to answer your questions, we will follow up with you to make sure your questions are answered. You're also all going to receive a follow-up email tomorrow that will contain a link to the deck and the recording, so you'll have that for your reference. So I'm pleased to introduce today our presenters for today's webinar. So first we have with us Kevin Smith. Kevin is the founder and CEO of SEEDCHANGE, as well as the founder of The Vault, a startup co-working and incubation space in San Francisco. Kevin led the development of new iShares products and businesses around the world, including development and introduction of equity and fixed income ETFs, and expansion of iShares to Mexico, Australia, Brazil, Chile, Peru, and Colombia. At Davis, Polk & Wardwell, Kevin ran IPOs, acquisitions, and other transactions for tech companies in Silicon Valley. And he also co-founded and led a business consulting firm in Moscow from startup phase to profitability as the largest consulting group in Eastern Europe. Kevin has a JD from Stanford University, an MA from UC Berkeley, and his BA from Vanderbilt University. So good morning and welcome to you, Kevin.
Thank you.
Sure. And we also have with us today Glenn McCrae. And Glenn is the Chief Strategy Officer for Early Growth Financial Services, bringing to this role more than 25 years of executive-level management experience. His strength is in providing financial and control expertise to small to mid-sized organizations to help them to maximize enterprise value. His specialties include organizational structure and management, financial accountability, business development, capital raising, budgeting, and forecasting. So hello and welcome to you, Glenn.
Thanks, Erica.
Sure. So before we jump into all this content, Kevin, do you want to just start by saying a few words about SEEDCHANGE?
You bet. SEEDCHANGE is an investment firm that focuses on early stage finance. A couple of years ago, I thought we saw an opportunity in the market to kind of help fix this gap in the financing stages of financing for companies, particularly at the early stage. So we're a registered broker-dealer. We focus only on early stage companies. We've developed a pretty strenuous process for analyzing and diligencing early stage companies, and over the last year or so we've seen about 1,500 companies, and we've helped finance 15 of them. And through that, I think we've learned a lot about the early stage market, about what issues companies face, and particularly about what issues companies face in growing and developing and getting financing. And that also led me to start The Vault as well.
Great, thanks so much. And Glenn, you want to just say a couple words about Early Growth Financial Services?
Sure, I'd love to. So Early Growth Financial Services is an outsourced financial services company. We help early stage companies anywhere from the earliest bootstrap stage all the way through C stage with financial accounting needs. So that could be paying bills, dealing with business registration, any of the nitty-gritty things that you have to do to run a business. And then we have higher level services that deal with putting projections together, board packages, investment packages, things like that to help people plan their business growth. We're a national firm with offices in New York, Chicago, LA, and we're based here in San Francisco. We've got about 450 clients from around the country.
Great, thanks so much. So without further ado, I'll hand it off to Kevin. You can jump right in here.
So I'm going to assume that most of the people in this call are working on a startup now. I'm also going to assume that most of you are going to fail just because that's what the numbers say. There are things we can do to improve the odds of succeeding. Living in Silicon Valley is helpful. Being born in Silicon Valley and growing up here is probably helpful too. Having Stanford on a diploma seems to be a reasonably good marker for success. But one of the most important things you can do to improve the odds of succeeding with your startup is understanding where the mines are and how to avoid those mines as you develop. There are several key issues almost guaranteed to kill a startup, or at least that we know are responsible for the death of many startups. And a little bit of thought, some careful planning early on, doesn't take a lot of time, doesn't take a lot of money, but can save an enormous amount of time, an enormous amount of money, and yes, also an enormous amount of headache a lot later. We, over the past few years, a number of people have done a fair amount of research on what makes a startup succeed. A lot more research, however, on what it is that is responsible for the death of a startup. I've been able to isolate some factors we know kill startups more than anything else. And while there's not a lot of hard data, there are a lot of observations, a lot of anecdotes. One very good study that I'm familiar with, done by a professor at Harvard who looked at startups over the course of 10 years, trying to isolate the causes of death of a startup. And he found that the #1 killer of startups is the founders themselves. Now, founders leave startups for lots of reasons. Some are good reasons, some are not so good reasons. But I think of a startup as a lot like a marriage. The relationship between startup, between founders, whether it's 2, 3, 4, is an extremely intense relationship. I recommend that people go approach it just like they would approach any long-term and very intense relationship. You go through a dating process. And you think a lot about how you're going to work with this person or this team. You think a lot about whether your values are aligned. You think a lot about whether and how you're going to handle really rough times, because you're going to have those too. And you try to think about what's going to happen if it just doesn't work out. And it doesn't. A very high percentage of startups fail because of founder disagreement. An even higher percentage of founders leave a startup for some reason or another. And if you think about it, you probably know people who have started a company and left before really hitting success, or perhaps even on the way to success, because they decided they wanted to go back to school, they wanted to change jobs, they wanted to go to med school, they wanted to move across the country, they needed to get moving with family and needed a much more stable source of income, weren't having fun anymore, maybe personal issues like they actually got divorced, had a baby. I've come across every single one of these in the last few months, and a couple of quotes that really resonated with me from founders. One founder to another told me that after 2 years in, he'd said to his co-founder, "Have you retired, or are you actually serious about developing this business?" I know another company where the founder decided that this was a lot harder. One co-founder decided it was a lot harder than he thought it was going to be and wanted to go back to something easier. Just didn't have the stomach for it. I know another company, actually a successful, well-funded company. In fact, both co-founders decided to leave. They decided to close up the company right after going through a $1.5 million round and successfully completing Y Combinator. Because they weren't interested in doing this anymore. They didn't have the passion for the product. So the point is that you have to expect that your founder, your co-founder, may decide at some point to abandon you. And that's okay if you plan for it. It's a disaster if you haven't. It's a disaster because if there are two of you, you have divided shares 50-50 early on, and you vested all of those shares, and a year later she decides that she wants to actually pursue her passion in Europe. You're stuck deciding whether or not to continue working on this company, knowing that 50% of all of your output is going to somebody who is no longer contributing or closing up. And economically rational thing to do there is to throw in the towel and start all over. So the way that I recommend that people address this is essentially a prenuptial agreement. As you're thinking about starting your company, as you're thinking about what it is you want to do and how you want to do it, a great way for directing the conversation among founders is by using a founder's agreement. There's a template that sort of floats around Silicon Valley, and if you haven't seen it and are interested in it, you can email us after the call and we'll get you a copy of it. It's not important for legal reasons, really. It's much more important as an agenda for directing a conversation, raising to the surface issues that you might not otherwise cover. So who is going to be involved, what it is you're going to be doing. I mean, it's not at all uncommon that to find out 6 months into a startup that you have different expectations of the market or of the strategy for developing the company. Good to really think that through early on to make sure that you're aligned. How much equity are we going to have? How much cash are we going to contribute up front? How much time are we going to devote? It's not uncommon to find some months into a startup that one of the team members was expecting to continue working at Google while doing this startup on the side, and he wasn't going to. He's not going to quit his job until you get a couple $1 million in funding. And a side note, you're probably not going to get a couple $1 million in funding if one of the key founders is employed elsewhere. And then a big question: well, what happens if we split up? Just assume that this may happen. How do we handle it? What do we do? It's best to address that with vesting shares. Nobody ever recommends that founders issue all of their shares fully vested right up front. The standard in Silicon Valley is a 4-year vesting plan for founders as well as for employees. Usually has a 1-year cliff, and that way you're covered. Let's assume a founder takes off in 6 months. He's not going to have any shares, and that's okay. That's going to make you feel a lot better about continuing to work on the company. Let's assume a founder decides a year and a half into it that he's going back to Apple. That's okay. He will have earned something for that year and a half. But he's not going to have a giant majority stake in the company, not enough probably to make you feel uncomfortable about continuing to work. Another issue is IP. Who owns the intellectual property that your product is based on? And making sure that you, in fact, own it. A lot of people believe that since they developed the IP, they own it. In many cases, that's not the case. So how do you know, and how do you maintain it? It's really common to find people graduated from MIT and started a company based on something they were working on in grad school, only to find that, in fact, MIT actually owns all of that IP. They don't own any of it. It's common as well for somebody to spend a couple of years while at Apple working on a great new product in their after hours, not working at all during company hours on this, or devoting any time or any attention at all to it, and nonetheless, it turns out that Apple is the real owner of what they've just developed, not the founders. On the next slide, there are a couple of, and these are honest quotes that I have heard over the last year, and variations of these probably hundreds of times. One, I couldn't afford the lab equipment for developing this product now, but I've got some funding and I'm ready to leave my company to start my own company. Another scenario, my co-founder is an incredible coder, and he's built all the code for this product, and we're ready to launch now. Another scenario, we're all the time meeting with strategic partners, potential hires, potential investors. Should we make them sign something? The answer in these cases is, of course, well, it depends. But in scenario number one, if you were using your company's equipment, even your company's laptop, even if you were only using it on Saturdays and Sundays, even if you were only using it in your own house, never on company premises, it's likely that the company owns the IP. And you can tell by looking at the confidentiality and invention assignment agreement that you probably signed when you started working there. And that probably lays out very carefully, very clearly, that the company owns anything you develop while you're employed by the company, with certain exceptions. And looking at those exceptions, really key. Number two, this is an important issue to discuss as a part of discussing a founder's agreement. If one of your co-founders built the code that you're going to use for your product, it's incredibly important that as part of starting the company, that she contributed that code and the rights to that code to the company. Maybe instead of contributing startup capital, maybe she contributes the code instead, and that is part of the startup capital. But if you haven't legally assigned the intellectual property rights to the code that was developed by somebody before starting the company to the company, then it probably is still owned by that founder, and if that founder walks in a year, he or she walks with the code too. And number three, well, you're constantly meeting with partners and potential hires and potential investors, and it's a big issue. How much do you want to disclose? With investors, you'll almost never find an investor that will sign a non-disclosure agreement. They just don't do it. And asking them to is a sign of naivete, generally. With strategic partners and potential hires, and certainly with employees that do come on, you absolutely ought to be asking them to sign an agreement, and you ought to be very careful about how much you disclose right up front. This is probably going to be a long developing relationship. You can disclose little by little as you go, but not right from the get-go. So a couple of important agreements for making sure that you are protecting your IP, proving that you own your IP, maintaining ownership of IP. Everybody that comes to work for the company should be signing an invention assignment and confidentiality agreement. Everybody, whether it's a full-time employee or a contractor, doesn't matter, and certainly if it's a founder. You're also going to want to cover whatever IP is being contributed to the company by founders in a founder's agreement. Make sure that you're very clear on what the company owns as opposed to what individuals own. You may want as well to have an invention assignment and confidentiality agreement that you use with potential partners, and also be careful about how much you disclose as you develop the relationship. And then non-disclosure agreements are useful for negotiations with people outside the company at the very beginning of the relationship. I'll tell you, from my point of view, having practiced as a lawyer in Silicon Valley for a long time, it's practically speaking, it's really rare that you'll ever find a company trying to enforce a non-disclosure agreement in court. I think, practically speaking, they're as an enforcement tool, they're virtually useless. What they are useful for is setting the boundaries of the relationship right up front, making sure that we've discussed how we're going to handle the confidential information that we're going to be disclosing between us.
So Kevin, I got a question for you, maybe a couple. In terms of best practices when it comes to IP, at a very high level, you would think that people might want to do a search to see whether they're infringing on people's established IP already. That might be number one. Number two is, it's probably pretty easy to get some high-level legal guidance on how to go about filing for a patent, but it's a pretty long process, and you may be in patent pending mode for quite a while. How do you approach those two issues in terms of searching for infringement and going through the laborious process of actually applying for a patent?
It's a good question, and I might add to that trademarks as well. In fact, start with trademarks because it's a similar process, but a little simpler and cheaper. You certainly should be doing a trademark search for company name, for any phrases or logos that you think are important. You want to make sure that you can get ownership to that. It's free to search on the U.S. Patent and Trademark Office website, which is uspto.gov. It costs $350 to file a trademark application. You can do it yourself. It's not necessary to hire a lawyer to do it. If you want to hire a lawyer to do it, or even just have a lawyer look over what you've already done before you file, that'll just cost you a few $100, and it's absolutely worth doing. I'm working with a company now that a year and a half in decided to change their name from what was a very good name to something that I think is less good, because they've run into so many other companies, not even in their space, but so many other companies with the same name. On patents, patents are quite a bit more complicated and more expensive, but it's absolutely worth spending a little bit of money to do a patent search. And it's worth doing that with a good patent lawyer, because what's helpful, first of all, you're not going to be paying a partner to do the search. It'll be a paralegal, so it's not going to cost an enormous amount of money to do a very good search of what's out there in this particular field. But second, a good lawyer can help you develop a patent application that drafts around what's already out there. And a perfect example is that at SEEDCHANGE, we filed patents on our own platform that are around the use and the process, the use of technology online in facilitating the investing process, and on the process itself. And while there's nothing like this in our particular space, of course there is with public companies, public financing, and in other markets as well. And so our attorneys were able to draft the application in a way that makes it clear that we're staking out a space in some ways adjacent to, but definitely not overlapping what already exists. When it comes to the cost of a patent application, filing a full-on patent application is probably going to run you, in a good case, $20,000, $30,000. You can, however, within 12 months of beginning to use publicly a piece of technology, you can file a provisional application that really just gets your technology on file. It's a lot cheaper, and then it will cost you just a few $1,000, and then you can upgrade that to a full-on application later.
Well, that's interesting.
Does that answer your question, Glenn?
Yep. Okay, so I am not, I promise, going to bore everyone talking about the details of accounting and compliance. I cannot think of two more boring topics unless you have a real problem that you have to deal with, and that is kind of the focus of why it could be a killer for you. So what we're trying to do is just point out a few key areas where, if you're mindful, if you take the appropriate basic proper steps up front, you will save yourself major headaches. And the whole nature of dealing with accounting issues and dealing with compliance issues is if you put the right amount of forethought in up front, your business can move smoothly, and accounting and compliance with tax and other regulatory issues don't have to be a hindrance to the growth of your business. However, if you don't deal with these issues timely and appropriately, they can definitely bring your business to a grinding halt, such as you've got investors that want to willingly invest in your business, but you're not able to get the paperwork lined up so that they can invest in your business. Can't think of a worse scenario. So let's go through a couple of these points so we can illustrate exactly what I'm talking about. So the first stage, and this is for folks who are just getting started, it might just be you. You might be running your business out of your home. You're incurring some business expenses. You're talking to some attorneys. Maybe you're paying some outside contractors to help you get the business up and going. Maybe you're just paying those bills right out of your personal bank account. That is to be avoided. When you start a business, even if you haven't established a C Corp or an LLC or some sort of separate structure, you could be what's called a sole proprietor. And as a sole proprietor, you can have a business up and running, just as if you had a formal business structure to it. It's just that there is an entity that you are focused on that is trying to generate business. It has a business purpose to it, which gives it a life of its own. So you want to set up a separate bank account, separate credit cards, whatever you might be doing to either collect funds from customers or to pay bills related to this business. You want to have separate accounts, even if it's in your name, even if you haven't set up a separate business entity yet. And the reason is that you want to segregate or separate your personal from business expenses, your personal from business activity. Reasons are twofold. One is tax purposes. You really need to keep good records for income tax purposes, so when you file your tax return, you can identify what your business expenses are because you do get deductions for business expenses. But more than that, you're establishing a track record for your business. When did you start your business? How much did you invest in your business? How much has it taken you to get to where you are today from both a time and money perspective? Investors want to see that information. They want to have a transparent idea about what's going on as you try to build your business. And so clean financial records are really important in making that happen. In support of these segregated business and personal expenses, you want to make sure you keep records of the receipts, because although you know it's a business expense, you're going to need to support the type of business expense it is so that when you generate financial records such as income statements or balance sheets or any kind of historical financial information, you know exactly how to characterize these expenses. And that's always really helpful when you're trying to manage a business so you can keep track of where your money's gone. What did you spend money on? Is it a one-time type of expense, or is it going to be an ongoing recurring type of expense? Did I exceed my expectations and spend a lot more in this area than I thought I was going to? Those kinds of things. It's really helpful to have receipts so you can understand what the purpose and the reason for paying those expenses were, and you can properly code them in your financials. The next point here is really important, which is understand what your tax obligations are. I think everybody understands that when you make money, you have to pay the government some taxes. Well, that's an income tax obligation, but there's plenty of other types of tax obligations. So let's start with income tax. Even though you don't make money as a business, say you're not profitable and you don't expect to be profitable, you still have a requirement to file an income tax return. If you're registered in the United States, you'd have a U.S. tax filing obligation. If your headquarters is in California, let's say, you'd have a state filing obligation. And the states can be very, very onerous in terms of exercising their rights to their perceived taxes. So even though you've lost money if you don't file tax returns, we've had clients who have had their bank accounts actually withheld. The state of California has made claims against those bank accounts and has actually required the bank to remit the funds to the state of California until the proper tax filings can be made. And there could be all sorts of explanations for why that is. You may have moved out of the state and thought you didn't have a tax filing obligation, but you didn't file a final return with the state of California. They don't know you've moved out of state. Things like that can happen. The other reason is if you have filed your business to, let's say, do business in California, you need to be current on your tax filings so that your business can be considered in good standing. And generally, institutional investors are going to ask for a certificate of good standing from the state of California before they will invest in your business. Now, certain investors aren't as particular as others about making sure they have that certificate of good standing, but if they've got a good lawyer in place, that lawyer will require that. And the reason is that there could be all sorts of hang-ups in filing what's called an article of incorporation in connection with this refinancing. And I know we're throwing some legal terms at you and some more involved concepts at you, but I just want to give you a flavor for how it can be a problem if you don't maintain your tax filings. There are also registration requirements in the city or the county that you may reside in. So it's good to work with professionals who understand what it takes to be registered in good standing, both at the municipal level, the state level, the federal level. If you're registered in Delaware as a C Corp, you have filing registrations there as well, and you won't be able to file your amended restated articles of incorporation if you're not current with your Delaware franchise tax filing. So it's important to just be aware of what your responsibilities are and to be sure that you're timely with your filings. If you're late with your filings, it's not the end of the world. Generally, when you don't have a tax obligation, there aren't onerous penalties. They can be very, very small. So it really does not pay to not be in compliance with your responsibilities. The next issue in here is dealing with payroll. You really do need to be aware of the difference between a contractor and an employee. I don't think we have time on this call to go into all the detailed differentiations between the two, but don't just assume that you can arbitrarily say somebody working for you is a contractor. There are rules that require you to comply with the definition of contractor versus employee. If they're determined to be employees, you could have a major problem. Let's say in California, the group that enforces that is called the EDD. And if the EDD determines that your people working for you should not be contractors but should be employees, they can be very difficult to deal with and unwind those kind of problems. The last item, if you have attorneys, they generally will take care of this for you in terms of your stock records. But this is the type of thing that falls under corporate governance, which is if you're running a business, you want to have a clean running business. Institutional investors don't like getting involved with companies that do not have a clear idea about their stock ownership. Certain things get involved when you raise money. You might have raised money under convertible debt. You may have converted a number of these debt holders to shareholders. Sorry, a little talk back there. I apologize. So anyways, it's important to keep those clean records so that whenever you go through a financing, whoever your potential investors are going to see you as a good corporate citizen, that they're not going to have misgivings about getting into bed with you, that you're going to be managing their money in a very competent way.
Great, thanks. Kevin, you want to move over to killer number 4 for structure?
Sorry about that. I thought I was off mute, and I wasn't. Glenn, before we move on, I'm going to disagree slightly with you about what you said at the beginning. I think that topic of accounting, tax, compliance is boring only if you're doing it all and doing it right. It's really incredibly exciting if you don't do it and you get hit up 6 months or a year and a half down the road with trying to pull apart your personal and your business banking, trying to pull apart expenses, trying to pull apart your tax records. It's an absolute nightmare, and I'll tell you, I made that mistake once with a company I started because, like everybody else, you're so busy doing so many things that you think, well, accounting is something I can catch up with later. And it's true, you can. It's just going to cost you a lot more and take a lot more time, and you're going to screw up a lot of things if you try to catch up at the end of the year. So my experience, and I've seen other companies make the same mistake, is this is an easy one where spending a little bit of time and money up front does make this a really boring issue. Or non-issue, I should say. Next, we're a little more than halfway through, so it's time for a pop quiz, and that's what this slide is, killer number 4. I'm going to go through each one of these questions. Think through or grab a piece of paper and jot down your answer to these. You're forming a company. You've already gone through the founders agreement. You've got you've laid out IP. You're very clear on what the how the team is going to work and what the product to be developed is, and you think you know where your strategy is going to take the company. It's time really to, and by the way, you've been keeping very good records along the way of your spending and maintaining separate accounts. It's time to, maybe even overdue, time to think about an entity. So, should you form an S Corp, an LLC, a C Corp, or an LLP? Should that entity be formed in California where you live, in Delaware because you've heard lots of people say that they form companies in Delaware, or in another state nearby that's cheaper and maybe a little bit easier to deal with from a filing point of view, like Arizona or Nevada? You're going to issue shares right from the beginning. You're also going to authorize a certain number of shares, and that number should be greater than the number of shares you're going to issue. Should you authorize 1 million, 5, 10, 20 million shares, some other number? You must, no matter what state you're forming in, have directors. How many directors should you have on the board? 1, 2, 3, or 6? Those are the most common numbers I've seen. If you do form your company in a state other than California, even though you're based in California, do you have to do any sort of filing in California? Your company is based in Arizona. Why should you have to file in California? And once you form this board, how often should it meet? I mean, is this a weekly meeting, yearly meeting, something in between? Most of these questions have very straightforward answers, and they're pretty binary, meaning there's a right answer and there are a few wrong answers. And I've heard every one of these. I've even heard every one of these recommended by lawyers or accountants or other professionals offering services to startups, and in some cases just egregiously wrong answers. Here's why. If you're forming a company, you almost certainly ought to be incorporating in Delaware, and you should be forming a C Corp. There's no other right answer. The only time an LLC or perhaps an LLP or an S Corp might make sense is if you're providing a service, not a product. And those forms could have better tax advantages for companies that are selling services as opposed to companies selling products. But one other caveat, if you ever think you might like to bring in professional or institutional investors, they will almost certainly require that you be formed as a C Corp in Delaware. In fact, a lot of charters of venture firms and other funds don't allow them to invest in anything but a C Corp that is formed in Delaware. And so it's much better to get it right from the beginning. This is another one of those things. It costs you a little bit of money. It takes very little time. It'll be a lot faster to incorporate in Delaware than any other state in the country. To try to change years later can be incredibly expensive. I'll give you one really egregious example. I once worked on a transaction for a large winery that was about to be acquired, but before being acquired, they were changing over from California registration to Delaware registration. It took them cost them about $1 million in various fees to accomplish that reorganization. It's not going to cost you that much if you don't wait that long. It's still going to be more expensive than you should have paid. Why Delaware? Well, Delaware is the only state in the country that has a very well-developed corporate legal and administration system. The Department of Corporations is notoriously efficient, fast, and reasonably cheap. You can get turnaround in Delaware in as little as an hour for filings. It'll cost you a little extra money, but it can be done. In California, you can pay extra money, and you still can't get turnaround in some cases, less than a week or 4. And the other reason is that Delaware has a very well-established corporate law, very clear corporate law, an entirely separate body of corporate law that they have taken great pains to from a thoughtful, practical, as well as legal point of view, develop in a way that is corporation friendly. No other state's done that. So it's going to be really clear to you. It's going to be really clear to your investors how to resolve any issue that comes up. It's going to be a lot better for you if you get sued, if you're in Delaware, and you can resort to the Delaware corporation's legal system, as opposed to any other state's legal system where you may be having your case heard in front of somebody who normally does divorces. How many shares should you issue? Well, should you authorize? You want a number that's reasonably big enough so that you don't have to go back and change your certificate of corporation every time you want to issue shares. You want a number that is easy to manage. I like multiples of 10 just because it makes the arithmetic easy to do down the road. And you want a number that's big enough. You'll find that you're going to want to issue shares to employees that are bigger numbers. So one share of a company that only is authorized 100 shares is it's 1%. That's a pretty good percentage, but only one share sounds like a lot less than 25,000 shares, even if 25,000 shares represents only 0.5% of the company. So people recognize arithmetically, intellectually, it shouldn't matter, but it does. It's a perception issue. You want to be able to issue bigger numbers of shares to employees. How many directors? Well, when you start, you should only have directors who are founders. Nobody outside the company should be a director. It's just not worth the time, the trouble, the attention of managing outside board members. And whatever good you get from an outside board member, meaning probably advice and support, maybe perhaps introductions, you can get that by bringing them in as an advisor instead of a board member. You ideally would have an odd number in case of some issue that needs to be settled by vote. In the state of Delaware, you can have a sole director. In California, you cannot. You must have at least 2. And for just good governance reasons, ideally you'd have more than 1 anyway. So the best scenario is you've got 3 key founders, and each one of them is a board member. If you've only got 2 founders, you're going to end up with 2 board members, not the end of the world. Yes, even if you've done everything right up to this point, you've incorporated in California, you've still got to register you've incorporated in Delaware, you've still got to register in whatever state you're based. And you have to register as what's called a foreign corporation, meaning that you are not registered in that state. And that means you have to file as a corporation, prove that you're in good standing in Delaware. You'll probably have to make update filings annually, and yes, you will also have to pay taxes annually, although it's a small amount generally. And then how often should you conduct board meetings? Well, this is one of the things institutional investors are going to want to look at least their law firm is going to look at when they come to invest in the company. They're going to want to look at the record of governance of the company, whether you have appropriately approved decisions, key corporate decisions made, whether you have had those approved, discussed and approved along the way. This is another one of those issues. It doesn't take a huge amount of time or cost to handle this regularly up front. It is a giant pain the longer you put it off. So if you haven't done it, you've been for 2 years, and now you're coming up on what you hope to be a Series A, and you've got to go back and get all your board minutes up to date. It's going to take a lot more time and a lot more money to do now than it would have if you've been doing it all along the way. You don't, by the way, need to conduct an actual formal meeting the way, let's say, large companies or public companies do. Certainly in Delaware, it's okay to conduct decisions or approve decisions by unanimous written consent. So one simply drafts the resolutions, has all directors sign the resolutions. It's a pretty simple process.
So we have a couple of questions here, Kevin, on this slide, particularly about the board of directors.
Sure.
And I'm hearing a big echo here, so I'll try and talk quickly. Stan Fell wants to know if there's only one founder, where do the other directors come from?
Yeah, if there's only one founder, again, assuming you're incorporated in Delaware, where you're allowed to have only a single director, you're probably going to start with one director. It's not ideal, but it's probably better than the alternative, which is bringing in an outside director. If, however, you have somebody who is been acting as a good, supportive advisor, somebody who's willing to take on that formal role, and it is a formal role that brings in a certain amount of liability too. So plenty of people who are willing to act as advisors are not going to be willing to act as directors. But you might consider, if you have somebody like that in mind, you might consider adding that person. But more likely than not, without knowing your specific situation, I would say more likely than not, you're going to be okay with one director for a while.
Okay, great. And then also, would it make sense to take on an inactive C Corp that was well set up initially?
Oh, assuming a shell corp rather than incorporating, is that the idea?
I think that's what he means.
I can't see why you would. If it's solely for the purpose of obtaining an entity, so you do this, you buy an entity instead of sort of off the shelf, instead of setting one up. Look, you can set up a new entity for probably $1,000 in legal costs. It's so simple and so quick and easy and cheap to do. I can't imagine when you'd do anything else, and that way you can be absolutely certain that you're getting a clean entity with no liabilities. And to be certain of buying an existing entity is going to require a certain amount of due diligence. It's going to cost you a lot more than it's going to cost you to form your own.
Okay, and then one last question here. If you're bringing on non-founders to your board, how would you compensate a non-founder director?
Assuming this is a non-founder who is an employee, you probably don't compensate them any other way than the way he or she is already getting compensated for employment with the company. If it's a non-founder director coming from outside the company, one of those sort of strategic advisors or mentors that you think is also going to be very helpful, even closer than being an advisor and taking on a more formal role. It's common to compensate outside directors with either cash or equity or both. And that really depends on a negotiation between you and that director. My advice would be not to promise cash. Startups don't have enough cash to spend in ways where you don't have to. It's worth giving up. It could be worth giving up a small amount of equity, but I would be careful to enter into an agreement with that outside director to make sure that you're really clear on what the expectations are for the director to, in a sense, earn that equity, what the expectations are for amount of time, for kinds of contributions he or she's going to make to the company in return for that equity. Really no different than you would think about the relationship of anybody who's contributing some sort of labor to the company and being compensated for it.
Thank you. That's helpful.
Last, developing what we've already been talking a little bit about, the issue of issuing securities. You're going to certainly do that when you form your entity. At least you're going to be issuing securities to the company founders. You're probably going to issue stock up front. And if you do, it ought to be restricted stock. It may or may not be common stock. There's a little bit of a trend in Silicon Valley to issue founder preferred shares, which has strong advocates as well as strong opponents. But if you issue the normal, follow the normal path, you'll issue restricted stock to founders. It's restricted because it can't be easily resold, and it's restricted because it ought to be vesting over a period of years, as we've already talked about, just like the stock you'd issue to an employee. If you issue stock to founders, you ought to immediately file with the IRS to obtain favorable treatment of the capital gains that you hope to get from that stock. You get 30 days from the time of issuance to get this filing into the IRS. You need to disclose that in your tax return for the year, and you get no plea, no appeal. There's no way out if you fail to hit the timeline. So absolutely critical that you file what's called an 83B, because it relates to the section of the tax code, section 83B, that you file an 83B election saying that you intend for your shares to be treated as provided in section 83B, and that you do that no later than 30 days after you receive the shares. Another issue that comes up a lot, you're looking for investors early on. What kind of investors should you get? Is it okay to take it from friends and family? It's often the easiest. Two issues with taking investment from friends and family. One is they need to be accredited investors. It's possible to take investment from non-accredited investors, but it brings along so many strings that it's just not worth managing. So under no circumstances should you really ever contemplate taking an investment from an investor who isn't an accredited investor. Two, taking investment from friends and family dramatically changes the relationship you have with those friends and those family members. So you got to think about what's it going to be like every Thanksgiving for the rest of your life, facing up to these guys when you took $100,000 from them, and unfortunately your startup didn't go where you wanted it to be, and it was never repaid or returned in any way. Next question, you're issuing securities. Well, you're certainly going to issue to yourselves stock, but if you're taking in outside investors, you're raising $500,000 or $1 million. Should you do convertible notes or should you do stock? The trend over the past several years in Silicon Valley and the East Coast too has been that early round, that seed round, is almost always done with convertible notes. They kind of act like stock, but from at least from the point of view of the investors, because they are expected to be converted into stock at some point. But they're really simple. They're really cheap to form, and you don't have to set a valuation, because the valuation is determined to be whatever the valuation is at the next issuance of equity. So that's the reason most people issue convertible notes to early investors instead of issuing stock. And last, do you have to file anything if you issue stock? Well, yes, you do. You need to file with the SEC. If you issue stock or debt, you need to file with the SEC. You probably need to file something with the state that you're in. And if you're issuing restricted stock, you certainly need to make sure that 83Bs get filed. The next page, there's a quote. I was thinking earlier, I should have modified this a bit. Starting companies is like launching a rocket. If you're off a tenth of a degree at launch, you'll miss your target completely. That's not totally true, because, as we all know, a startup is just one giant experiment. And starting companies is like launching a rocket. If you're off a tenth of a degree at launch and you don't make constant corrections, then you'll miss your target. Some of the ways that you can help making sure that you're on target are with addressing the issues that we've talked about up front, with a few very simple agreements, a lot of more complex conversations, discussions amongst the founders, and by filing the right documents and making sure that you're setting up the right financial and legal structure right from the beginning. That's all I got. We've got a couple of minutes if anybody has questions.
Yes, we have another question here about the board of directors. Lots of questions about that today. So Jaideep wants to know, what are typical expectations of the directors?
Expectations of the company and startup, I suppose. Again, I guess I'd reiterate that I'd be really careful about bringing in outside directors. On the one hand, I do think it's a useful check, it's useful input. The right directors are very supportive and helpful. In some cases, can even be good marketing. I think Lending Club sort of famously brought in very high-profile directors pretty early on, and got a fair amount of marketing input just from having those names associated with them. But it does require a lot of work, and directors are going to expect, they may expect to be compensated. They're going to expect to have a lot of input and a lot of insight into what you're doing. They're going to want to see regularly everything, finances, everything you're doing. They may question you on your decisions you're taking or you're thinking you're taking. Again, that may not be a bad thing. That actually might be a very good thing, but you have to be careful about the director you bring in. They're certainly going to expect you to buy them a director and officer policy. They may want other insurance policies, like a key person insurance policy if they consider you really important, errors and omissions policy, and perhaps a few others, but they'll certainly want a D&O policy. It's not terribly expensive, but it's going to cost a few $1,000s a year.
Okay, thanks. And then we have a question here from Richard. He wants to know what you think about allowing friends and families to join in a round of funding by professional investors.
Yeah, again, only if they're accredited investors. One of the things, in the ideal world, you'd have a smaller number of investors rather than a larger number of investors. Managing the shareholder base gets to be complicated, expensive. You need a decision, and you've got to have shareholder approval. And you know, Uncle Dean moved or is hiking off in Nepal for a year, and you can't reach him. you could be stuck. So you want to make sure that you'd like to have fewer rather than more. It's rarely worth taking an investment from somebody for, say, $10,000, $20,000, to be honest. Then the other issue really is just the personal issue. Even if they are accredited investors, even if they are investing, or maybe particularly if they're investing a large amount, how is that going to affect your relationship over the years if the startup isn't successful?
Thank you so much. We're up against time. And I have this terrible echo. So I'm going to not have a big close and just say thank you all very much for joining us today. And I hope you found this useful. And thank you so much to Kevin and Glenn for all this great information. And we hope to connect with you all again soon. Thank you.